IR35 effectively is a rule whereby a limited company contractor has to assess by assignment whether but for their limited company they'd actually be an employee of the client on site, and there are set criteria that they measure against to make that decision.
The current law in the private sector is that the personal service company is responsible for assessing whether or not the work that they do for an end user is actually one of employment. And if it is, then the IR35 rules apply and they have to deduct PAY and national insurance on all of the income derived from that piece of work.
Unfortunately, the legislation itself is cumbersome because it requires you to look at whether somebody's employed or would be employed, were it not for the sake of their personal service company, or generally self-employed. And the only way you can measure that is by reference to a number of employment status tests that have been handed down by the courts over a number of decades. And unfortunately, some of those tests can be subjective.
It's been around now for 20 years, and for the vast majority of those years it's meant that the end engager really hasn't had to be concerned about it, or indeed any agencies involved in the supply chain. The contracting company has been responsible for, in effect, checking whether or not their workers, or themselves when they work for an end client, would be deemed to be an employee if they ignored their own limited company. Those rules are changing. They've changed in the public sector already from 2017. And from April 2020, they're going to change in the private sector as well. And what that means is, although the tests as to whether you are a deemed employee or not don't change at all, the responsibility now passes to the end engager, the end client of that contractor services.